Welcome, everyone. We're just going to give people a few minutes to log on. Okay, welcome everyone to Services for Independent Living's webinar today. Our topic, People's Rights in the Guardianship System and Alternatives to Guardianship. Today's webinar has been brought to you by Services for Independent Living and Disability Rights Ohio. My name is India Jones. I am the Community Services Manager here at Services for Independent Living, and I will also be your webinar facilitator for today. Just wanted to go over a few housekeeping rules. All participants will be muted during the webinar. If you have any questions, please feel free to type them in the question box and we will attempt to answer them at the end of the webinar. A recording of this webinar will be available on our website in the archived webinar section at www.sil-oh.org. A copy of the PowerPoint that will be presented today will be available for download in the handout section, so please feel free to download that. There will be a satisfaction survey that will pop up at the end of this webinar. Please fill it out. This is how we get our feedback on how we are doing, and this is also how we get ideas on other topics that you guys would like us to cover. If you would like to receive 1 CEU credit for attendance, and this is only offered to licensed social workers, licensed independent social workers, and social work assistants, please select yes on that particular question on the survey that will pop up directly after this webinar. Now, I would like to turn everything over to our wonderful speaker that we have today. Her name is Maggie Scotece. She is an attorney at Disability Rights Ohio, and she will be walking us through the topic of guardianship. Thank you so much, Maggie, for being here with us today.
Absolutely. So as India said, my name is Maggie Scotece. I'm a staff attorney with Disability Rights Ohio. I am in our short-term team, and I practice mostly with regards to guardianship, mental health questions, and helping people get general reasonable accommodations. You can go to the next slide, India. Thank you. So if you don't know about DRO, we are the protection and advocacy organization for the state of Ohio. So we're federally designated, and our job is to advocate for the human, civil, and legal rights of people with disabilities in Ohio. So we do a lot of different things as a part of that. We provide information both to individuals as well as the public generally. We provide resources. We have a lot of self-help resources on our website. They're really wonderful. We do legal advocacy through direct representation as well as advising attorneys who represent people with disabilities. We do some investigations, mostly for abuse and neglect when it comes to residential facilities such as nursing homes, intermediate care facilities, and stuff like that. We do monitoring of those facilities, including jails as well. And then we also do some policy work to help inform our legislators about what the importance of what they're doing is in terms of how it impacts people with disabilities in the state of Ohio. So we also have several teams in DRO. We have our community integration and civil rights team. We have our education team, which is exactly what it sounds like, helping people with IEPs, and that's up in K through 12 education. Once you get into post-secondary education, that's going to be more about the short-term assistance team, which I'll talk about a little bit later. We also have an employment team, an abuse and neglect team that does most of our monitoring work, a WIPA team, which can help people understand their benefits and how they can manage their benefits and any questions they have about that. our intake and short-term assistance teams, which do a lot of resources and referrals for clients, our policy and outreach teams, and then our rep payee reviews, which is where we have reviewers who are tasked by Social Security to review any sort of complaints that come in for people in the state of Ohio about the behavior or the actions of representative payees. So they can actually conduct investigations and help people understand whether or not an abuse or something is occurring for a representative payee. Next slide, please. So a question I often get when I start these presentations, what's this all about? So a lot of questions we get are, how do you help an adult who has trouble making decisions for themselves? What if something happens to an adult with disabilities? Can the family step in to fix it? And will doctors, landlords, banks, et cetera, other institutions still be able to talk to a family after a child with disabilities turns 18? If you do absolutely nothing, if your child turns 18 and you don't have anything in place, you may not be able to be involved in those situations. You may not be allowed to talk to doctors or make doctor's appointments or talk to banks or anything like that. But a lot of times we see families being pushed into guardianship. Next slide, please. A lot of times we hear the question, is guardianship the only option? Or we'll hear, you know, the school or the doctor or the board of DD told us guardianship is the only option for my child. That's the only way I can stay involved. That's the only way I can protect them. And a lot of times parents have this concern if that's what they have to do in order to protect their child. Next slide. But in most cases, the answer is no. Most people don't need a guardianship, and most families can manage their decision making and stay involved in the adult child's life, even without a guardianship in place. Many people with disabilities don't have guardianships and never need guardianships in their lives. Even people who have issues making decisions. There are alternatives to guardianship that are less restrictive and are actually easier a lot of times for the family and for the person with disabilities to adjust to. And like I said, a lot of times parents and families get concerned because organizations such as schools, hospitals, et cetera, will suggest guardianship and sometimes even push it even when it's not needed. Or parents will not understand what options they have and the child will turn 18 and they get guardianship because they think that's the only option and they have a critical decision they have to make, such as healthcare or schooling or housing or something like that. Next slide. So a lot of what I'm going to talk about today is the decision-making process, capacity, competency, and what it means to make a decision, because that's where the question of guardianship versus the alternatives to guardianship really come in. We want to reframe the conversation about what it means to have needs in helping make decisions. Next slide. So the basic principles I want to start off with is everybody needs help to make some decisions. So I am a millennial and I still need help making decisions, especially big decisions. So if I'm going to buy a car or rent a new apartment or buy a house, there are people that I talk to in my life about that decision that I'm making because I need their input. I need people with more experience and people who have made those kind of decisions before. And supported decision making is often the same practice, just on different scales. So it's not uncommon to use these same tools for people without disabilities. And that's kind of what we want families and workers to understand, is that it's not unique to people with disabilities. Everybody needs help making decisions sometimes. And so before choosing guardianship or alternatives, we want people to understand how they can assess the areas in which the person needs support and pick the solution that's actually best for the person with the disabilities in their family. Because a lot of times that's not going to be guardianship, but people don't know that. Next slide. So another thing you're going to hear me talk about a lot is a continuum of support. So we like to think about supported decision-making and assistance in terms of assisting people with disabilities in the terms of a continuum. So there are people who need very mild assistance in terms of making decisions or helping them maintain daily living. And some people will need a lot more support, and it's still support. It's just a different continuum in the amount and span that's happening. We always want people to start with the least restrictive options before moving on to the most restrictive options. And that's just not our personal preference. That's actually what the law of Ohio says. You have to consider all of the least restrictive alternatives before you can actually get a guardianship. That's what the law requires. Now, is that always enforced? No. A lot of even courts don't understand how to actually understand what the least restrictive alternatives are for guardianship, but really you should be considering what the alternatives are before you're looking at guardianship. The assessment is different for every person. It's not one size fits all. So that's another point I want to talk about real quick is if you have questions about any specific circumstance in your personal family, I would love to talk to you about those particular circumstances. But as this webinar is being recorded, I would ask that you not ask that in this context. I'm going to provide my contact information at the end of this webinar, and I'm happy to talk offline about it. I'm happy to answer general questions on the webinar, but for your own personal privacy and confidentiality, I don't want that to be showed with other people, and so I prefer if you ask those in private through my email or through DRO. And then also, we want you to look at this in terms of creativity and being able to consider different ways of providing support that may not fit a cookie cutter, but may fit your family or your child way better than a guardianship ever would. Next slide. So why are we talking about the alternatives to guardianship? So as I mentioned already, you have to consider the least restrictive alternatives prior to looking at guardianship under Ohio law. But there's a lot of other reasons. Guardianships can be really difficult to terminate, especially if they have been established for quite a long time. Once the guardianship is established, the burden is on the person with the disability to prove that they no longer need a guardian. And that's a pretty high standard, especially for a lot of courts that like to default to guardianship. And if they assume that everything's been going fine under the guardianship, they're not readily going to end that guardianship because they're worried about something terrible happening if the person doesn't have a guardian. Ongoing guardianship means there's ongoing court involvement and required reporting. That's something that I talk to families a lot about. A lot of families don't understand that getting a guardianship means that the court is essentially going to be part of your family for as long as the guardianship lasts, and that could be your child's entire life. And this can come up a lot, especially when we have families who have other marginalized identities, such as queer families or BIPOC families, who may suffer other oppressions in the probate court because the people who are making the decisions about the guardianship don't look like them or their family. So it's something to keep in mind. It also means that if somebody disagrees with what you're doing as a guardian, once you have a guardianship established, they can always go to court and ask that you be removed as guardian and they be put in place. We see this a lot with hospitals who disagree with the decisions that guardians are making about healthcare. And they will file a complaint at the probate court and ask that the guardianship be removed and put into a third-party guardian who the hospital knows will agree with whatever the doctors say. There are also many alternatives to offer necessary support with less intrusion. Alternatives that are a lot easier for you to manage in your life because guardianship requires ongoing reporting. If you are a guardian of the person, you have to file a report every year and an evaluation every year. And if you're guardianship of the estate, you have to do a lot of financial reporting in order to maintain that. And also, and this is the most important part, research shows that people have better health, better safety, more independence, better integration in their communities, better employment, better wages, and even longevity of life for people who have greater self-determination. So the more involved the person with the disability can be in making their own decisions for their life, the better their quality and longevity of life is going to be in the long term. Next slide, please. So where do you start when you're thinking about what's the right option for you or your family? The first thing we always ask people to do is do an individualized assessment of the person's abilities and the various needs that they have. So what areas of decision making do they struggle with? Because for instance, I can get up and decide what I want to eat for breakfast in the morning, but if I'm talking about doing a financial investment, I need somebody to talk to about that. So we want you to look at an individualized assessment that looks at different areas of decision making and different kinds of decision making, because not all decisions are equal. Next slide, please. So one option for assessing capacity is the stoplight tool. And this is a really easy tool to understand. It just goes through and asks different questions about whether or not the person can do it on their own, if they need support or assistance to be able to do it, or if they need somebody to actually do it on their behalf. And it allows you to get an idea of what areas of life the person might need assistance in, and even if you are looking at guardianship, what kind of guardianship might be appropriate for the person. Next slide. So again, this talks about discrete areas of decision-making capacity and recognizes differences in capacity. So you may be able to make a decision, all sorts of decisions, as long as you have support, but there may be a couple that you really can't make on your own. And so it allows you to get a really complete picture of the person that we're talking about and what their capacity is and what their need for support is. You can get multiple perspectives. So this is just a sheet of paper that you can fill out. And I often encourage parents to do one with their child, do one with their spouse or whoever they have as somebody who assists them in parenting if they have somebody who does that. teachers, friends, professionals, a caregiver, anything like that. All people can be involved in helping understand the different ways that child or that young adult interacts with decision making. And this is really important because sometimes parents will see a child come home from school or come home from their programming and think they don't make any decisions when they come home. But what they don't realize is they've been making decisions all day at their programming or at school. And so they have reached decision fatigue. And so the parent doesn't know quite what their capacity is because they're not seeing it on a daily basis because it's happening outside of the home. So that's why we really encourage people to look at a lot of different perspectives and get input on the different ways that the person's capacity manifests in different areas of their life. We also like to start by considering the abilities. So what can the person do? Once we know what they can do, then we can fill in what they need assistance with. And it allows you to consider support. So maybe, for a particular area, I have some clients who, for a particular area, for things about their interpersonal relationships or something like that, they will designate that they want to talk to an older sibling about that, or a cousin about that, or somebody who's closer to their age and they don't have the same concerns about talking to their parent about it, because maybe they just don't feel like talking to their parent about whatever that particular topic is. And so it really allows the person to have some independence and some choice in terms of who their support is for that particular decision area. It also helps you identify and narrow the areas of need. So even if you are looking at guardianship, you may not need a full guardianship. You may only need a limited guardianship, or a guardianship that's only in place for, this time to this time or something like that. It gets you a fuller picture of what you're actually looking at in terms of support needs before you create a tool that's not going to help the person or overly constrict them in terms of their decision making. Next slide. So another option, and this one tends to be used for attorneys. That's who it was designed for, is the practical tool. It's just a different version of the same tool essentially. And again, it helps you determine what areas of need are there for support in decision making. Next slide. It's a little different in that it has this layout, which is to presume that guardianship is not needed, right? We want to start with the least restrictive alternatives. You have to clearly identify the reasons for your areas of concern. Ask if the condition is temporary or maybe reversible. For instance, people who have cyclical mental health conditions may not need a guardianship because most of the time they can make decisions on their own. You may just need to have a plan for if their symptoms relapse or if they go off their meds for some reason, because that happens, and allows you to determine what the actual needs of the person are. It also asks you to determine if community resource or accommodations can address these concerns before looking at making decisions in terms of controlling their decision-making ability. Consider whether a team could help people make decisions, identify abilities, both strengths and limitations, and address potential challenges for identified supports. It allows you to appoint a support or a surrogate consistent with the person's values. So a lot of times we advise individuals who are especially trying to terminate their guardianship to create this process, to create a system of supports so that they can show, if I get to, because a lot of courts have concerns, especially if somebody's been under guardianship, they don't have the experience in making decisions. And so it's really helpful to be able to show, look, I understand that I may not be able to make this decision because I can't predict every decision I'm going to have to make in my life, but these are the people I've designated that I can go to and talk to about this decision if I approach a decision that I've never made before or I don't know how to make. It also limits any necessary guardianship order. Again, you may not need a full guardianship order, and so if you don't need it, we encourage people to not seek a full guardianship because of the restriction it causes on people's rights. Next slide. When to start? This is a really common question we get. We encourage clients and families to start planning early what method they will use to support their child. I know some agencies encourage starting practicing this, like at school, as early as age 12. A lot of times when we're talking about transition planning for young adults, we're talking about 14 to 21 in terms of transitioning them from living in their parents' home and being under their parents' guardianship, natural guardianship, to actually what it would look like if once they reach the age of 18. We also ask parents to assess which areas the child needs help and then consider what methods are best to support the family and provide that support. So another option is you can test out things if you start early. You can see, bring in teachers and schools into this process and see what works for your child. Try a couple different methods. See if there are different supporters that work better with the child or with the family or makes it easier for them to complete the process. And also, you can always call Disability Rights Ohio to discuss options. This is what I talk about for most of my day, is guardianship and the options for and alternatives to guardianship. We will need the permission from the person with the disability to be able to discuss any options or any specific guidance, and that is because we have a client direction policy, which means we advocate for the wishes of the person with the disability, even if they're under the age of majority. That is our job. And so we will ask to get their consent before we discuss anything with you, but as long as they're okay with us talking to you, we will absolutely talk about options. Next slide. So now we're going to talk about guardianship specifically, because I understand guardianship is a reality for some people. Maybe they already had it, or their family actually is in a place where they need guardianship. And so I want people to understand what guardianship actually looks like in case that is the reality for you or your family. Next slide. So we're going to talk about terms first. So I've mentioned most of these before, but I'm going to define them for you now. So when we're talking about a guardianship of the estate, that is finances, property, and benefits. Guardianship of the person includes medical decisions, housing, food, clothing, shopping, and safety decisions. It is very common for courts to only do a guardianship of the person if the ward doesn't have a lot of property or finances to control, because they don't want to have the additional reporting requirements put on the guardian if they're not going to have anything really to report on. So it's not uncommon to just have a guardianship of the person. But some people do have full guardianship, including person and the estate. There's also an emergency guardian, which is what it sounds like. It's a guardian who's appointed on a temporary and emergency basis for a short term until a full hearing can be held. So emergency guardians are appointed without the person who's the ward being present at the hearing, and it is a temporary appointment until the ward can be present at a full hearing at a later date. This often happens if a young adult or somebody with a disability is in a terrible accident or something like that, and they didn't have the planning set up in advance, and so they need somebody to make decisions in the meantime, and then the court will revisit it once the person is able to attend a hearing. You also hear of co-guardians. Co-guardians are when more than one guardian is appointed for the same ward. Some counties will not appoint co-guardians. A lot of times you see probate courts hesitant to use co-guardians, especially if co-guardians are both parents or a divorced couple, parents of a child, because they are very concerned that when the co-guardians don't agree, they're going to come back in front of the court and ask the court to make every decision for them. And courts don't want to be having wards or guardians in the court that often. They don't want to be refereeing disagreements between guardians. And so a lot of times, if the court has any indication that there's going to be disagreements between the guardians, they will not appoint co-guardians. And if they did appoint co-guardians and you keep coming into court to litigate specific issues, the court may eventually appoint a third-party guardian so that that no longer happens. Some counties do like co-guardians, especially for transition planning or succession planning for guardianship, because if you are the parent of a child and you get guardianship of them, chances are your child is going to outlive you or outlive your capacity to be guardian. And so courts will encourage people to sometimes have a co-guardian appointed to transition from one guardian to another, so it's not as difficult for the ward or for the guardians to transition that decision-making power. But that tends to be in limited circumstances, and it's something that you should definitely be talking about with, I would encourage you to talk about it with DRO and with the court if that's something you're interested in doing. There's also limited guardianship, which is an option in Ohio. The court can limit the decision-making and powers of the guardian based on the capacity of the ward. It's pretty uncommon. I have only seen one limited guardianship in my time working at DRO, which has been almost 3 years now. And that wasn't for the benefit of the ward. That was giving decision-making power to a third party who was not the ward. So limited guardianships can be an option though. And one thing to keep in mind is if you are a service provider for your child, you cannot be a service provider and a guardian unless you get a special exemption by the court. And this is for family members only. If it's a third-party guardian who's not related to the ward, that's different. You can do both. But if you are a family member, you cannot do both. And So a lot of times, especially if there is a married couple that has a child and one of them wants to be guardian, since co-guardians are often not liked by courts, one parent will be guardian and the other parent will be a service provider. That way they can still do both. Next slide. So how do you do a guardianship if that's what you decide you want to do? The person who wants to be guardian applies at the probate court. There is an application packet. It's all local, so you have to find which local court you're applying at. Sometimes they have a whole packet just ready that you can take and fill out. Sometimes they just have a collection of different forms that you have to guess which ones you need and fill out. If that is the issue, I would encourage you to contact DRO and have us help you figure it out, because sometimes courts are not really willing or able to walk you through the process of what forms you need. Sometimes they are, but sometimes they're not. You will have to do a background check. That's something you have to go through in order to be appointed as a guardian. You have to do that prior to your appointment so they can determine whether or not you are a fit guardian. So a guardianship hearing is actually going to be determining two things: whether or not the person who is the potential ward needs a guardian, and whether or not the person who is applying for the guardianship is a fit guardian. You also will have to pay a filing fee. That depends on county to county, but it can be I think the most recent case I helped with, the filing fee was like $150 to actually file for the guardianship. And this is the most important part. If you are filing for guardianship of somebody who has not previously had a guardianship, you will need to have an expert evaluation done. For the first one, it needs to be either a physician or a psychologist who's licensed in the state of Ohio. And it has to be recent, so within 90 days of the filing date of the guardianship. So that can be hard because it can take 6 months to a year to get an appointment, to get an expert evaluation done, to be prepared for a guardianship hearing. So if that's something that you're thinking about doing, you need to start planning in advance, because it can take quite a while. And you can't do it super far in advance, because remember, it has to be 90 days from the filing time. And also, if you are filing for a guardianship as for the minor, once they reach the age of 18, you cannot file before they reach the age of 18. So you can't wait until they're 17 and a half and file for guardianship so that it's effective by the time they reach the age of 18. You would have to wait until they actually turn 18 to file for the guardianship. Once you've actually filed for the guardianship, the court will schedule a hearing, and they will send an investigator out to meet with the ward. The investigator is supposed to provide notice to the ward of their rights and of what's going on, and reports back to the court on the necessity of the guardianship and whether or not they think it's appropriate. Now, like I said, they're supposed to provide notice to the ward of the hearing and their rights. That's often not what actually happens. It is very common for people under guardianship to have a guardianship for years and have no concept of what their rights are, because it was never explained to them by anybody. So if you are aware of that happening, the ward needs to be aware of their rights. That's their legal right, is to know that. And so if you don't know what their rights are, I'm going to talk about them in a few minutes, but you can also reach out to DRO, and we have information that we can provide about what the rights of a ward are, including rights during the hearing process. Next slide. So it also depends on whether or not the person is contesting the guardianship. There are some people that want a guardian appointed to help them manage their affairs. And so if it's not contested, they may not even have a hearing. They may just determine that the person who has applied for guardianship is appropriate and appoint them and issue the letters of guardianship. If it is contested, the court will schedule a hearing, and the potential ward, has a right to have an attorney appointed to represent them at that hearing, even if they cannot afford it. So if they cannot afford it, the court must pay for that attorney out of the court coffers. The other thing they must pay for, if the ward requests it, is an independent evaluator to do a second expert evaluation of the ward and report back to the court about whether or not a guardianship is appropriate. Those two rights continue for the entirety of the guardianship. So at every hearing, the client has a right to have representation by an attorney and have an independent expert evaluation done if the guardianship itself is being reviewed. They also have to provide notice to the next of kin. So if you are separated from your spouse, or there are brothers or sisters or something like that in the picture, they have to be given notice about the hearing so that they can attend and put their name in the ring for guardianship if they wish to. And then the court holds a hearing. And like I said, they're questioning a couple of different things: whether or not the individual is incompetent and unable to make decisions for themselves, and that requires the safety of a guardian to be put in place, and whether or not the applicant for guardianship is suitable to be a guardian. The court legally must require and consider evidence of less restrictive alternatives, but a lot of times courts don't do that. So if there's concern that a person who has a guardian or is undergoing guardianship proceedings hasn't been allowed or able to present evidence of less restrictive alternatives, that's something you would absolutely want to contact disability rights about. Next slide. So next thing that happens is if the court agrees that the person needs a guardianship and the guardian is fit, then they will issue letters of guardianship. If you have a guardianship over a person, I would encourage you to keep the letters of guardianship on you at all times. So for instance, my partner has guardianship over his sister, and when he got guardianship, I told him he needed to keep a copy of them at all times, keep a copy in his records, because anytime you want to make a decision for somebody, for an agency or an organization that is new, you may be required to produce a copy of those letters of guardianship. If you lose the letters of guardianship, you can get a new copy from the court, but I always encourage people to just keep a couple of copies hanging around so that they always have them if they need them. You also have to have ongoing education for guardians. There's generally a 6-hour course for the state of Ohio that you have to do within, I believe it's 6 months of being appointed as guardian. And here's the other thing, the court is always the superior guardian. So remember how I talked about having a guardianship means the court is going to be involved in your life? That's what that means. The court is always the final decision maker about things. So if you don't agree with something the court's doing, there's going to be the decision, the ones that matters. And if the court thinks that something you're doing is wrong or putting the ward in danger, you may be removed as guardian or have some other action taken against you by the court. If you are guardian of the estate, you have to file an inventory of all the property and assets of the ward. You have to file, if you are guardianship of the person and the estate, or just the person, you have to file an annual report of the guardianship, which indicates where they're living, what their life has been like, what the capacity is, any changes and that sort of thing, and a plan for the guardianship. So what you are doing to provide for the ward. And the ward has a right to the guardianship to be reviewed on an annual basis. Now, that differs from county to county. So some counties say every calendar year you can have a review of your guardianship. Some counties say it has to be a full 365 days from your last hearing for your next guardianship. So it can be hard. You may have to inquire to the court what exactly their policy is, but generally if it's been 365 days, we encourage people that if they would like to have a hearing, they can request a hearing at that time. And again, for any of these review hearings, the court must appoint an attorney and an independent evaluator if the ward requests that. Next slide. So there's a lot of rights and responsibilities when it comes to guardianship. Next slide. But there's also a fair amount of rights that are retained by the ward. Being guardianship of the person does not mean that you have control over every decision the person makes. Next slide. So a ward has a right to be treated with dignity and respect. They have a right to privacy. So that means privacy of the body. They have a right to their own personal individual privacy and private uncensored communication, whether that's by mail, telephone, in person, and that can be with friends, with family members, with attorneys, with service providers. And if the guardian wants to restrict any of that communication, they're going to have to make a really good argument as to why they have the right to do that, why the person they're restricting is so dangerous to the ward that they can't have communication. They also retain rights to control any aspects that are not subject to the guardianship. So if you only have guardianship of the estate, you don't have the right to determine where the ward lives or what kind of medical care or anything like that. They have a right to appropriate services. So if they don't think they're getting the right services that they need, they can actually go to the court and file a complaint against the ward saying that the guardian is not doing their job in terms of making sure they have the correct services. They have a right to a safe, sanitary, humane living conditions in the least restrictive environment as possible. So just because you're a guardian doesn't mean you have the ultimate authority to determine where the person lives. If you are putting them into a very restrictive setting and they don't need to be there, you may face ramifications in court for not following your responsibilities to the ward. Most wards retain the right to marry if they're legally able. This can get kind of tricky. There's not a whole lot of law on this in the state of Ohio, but generally speaking, in terms of marriage and procreation or consent to any sort of reproductive healthcare decisions, stays with the ward themselves. And they have a right to determine whether or not they want to have children, not want to have children, have an IUD put in, or any sort of ongoing birth control, or get married at that time. And we've actually defended people who've come to us about these questions. We've had people who've been told by the court they had to get a divorce because the guardian didn't consent to the marriage, and we were able to successfully stop that and allow the ward to make the decisions about who they wanted to marry. Next slide. So wards still have the right to equal treatment and non-discrimination, including discrimination on the basis of their disability. They have a right to explanations of medical procedures and treatment. So even though they may not have the ability to consent to a procedure, they still have a right to be informed about what's going on. They have a right to confidentiality of personal information. So you still cannot be going around talking about everything about the ward just because you have the legal right to the information. They have a right to review all the personal records related to their medical records, their estate, anything like that. They have right to private communication with an attorney, an ombudsman, or other advocate. They have the right to drive if they are legally able and can pass the driving exam. And most wards retain the right to vote. Next slide. As I mentioned, they also have the right to an annual review hearing. At any point in time, they can petition the court to modify or terminate the guardianship. So, and that may be in the form of a complaint against the guardian. So if they recently had a review hearing, but something has happened, some violation of their rights has happened, that they have a concern about the guardian themselves, and may not be technically allowed to review the guardianship at that time, they can still file a complaint against the guardian with the court and potentially have a hearing about that. Like I said, they have the right to an attorney and independent evaluator at court expense if they cannot afford it. And they have a right to file grievances against the guardian, including the court review of the guardian's actions through a complaint, removal, replacement of the guardian, and restoration of rights. And here's the other thing about the complaint process. The ward is not the only person who can file a complaint. So if you have concerns about the way a guardian is treating a ward, you as a third party can actually file a complaint with the probate court about what is happening. Sometimes we see this from facilities or from hospitals who disagree with the way a guardian is handling their control of the ward's decision-making power. Next slide. So I mentioned that most wards retain the right to vote, and that is true. Most people under guardianship still have the right to vote. Guardians cannot determine whether or not their ward votes, or how they vote, or vote on the ward's behalf. The only time that you are restricted from voting if you have a guardianship is if the court has made a separate and independent determination that someone is incapable of capacity for the purposes of voting. If that happens, they have to make a separate finding in court about that and inform the Board of Elections where the ward lives to let them know they can no longer be a voting citizen. Anyone with a disability can receive assistance with voting. So if you have any sort of disability at all, you can get a reasonable accommodation to assist you with voting, whether that is having a personal assistant come in and assist you, or getting access to different voting avenues, such as using a remote ballot or curbside voting or something like that. If you have any questions about voting rights with disabilities or access to voting as somebody with disabilities, please reach out to me. That's the other thing I spend a lot of my time on, is talking about voting rights for people with disabilities. And assistive technology is available at most voting sites. And if it's not, they have a requirement to accommodate you in any way, in the way that you need to be able to access your right to vote. Next slide. So guardians have a lot of responsibilities. They have to follow all the laws and all court orders, even if you don't like them. So like I said, the probate court is always going to be the superior guardian, and it's not uncommon for guardians and the probate court to butt heads about different decisions. And so it's important to remember that you're responsible for following not only the laws of the state of Ohio, but all of the orders and directions of the court. Even if it's not an official order, if the court has told you to do something, I would always suggest that you do it or reach out to an attorney to talk to how to address it, because they ultimately are the decision maker. It is very hard to review a probate court's decision-making powers, especially in the state of Ohio, because they are given ultimate authority. A guardian has the responsibility to make decisions in the ward's best interest. So the decision that a reasonable person would make if they were in the ward's positions. And this is where it comes to when we're talking about decisions about specific healthcare issues. So last year, for instance, we saw a lot of questions from probate courts actually about COVID-19 vaccinations and whether or not guardians could consent to COVID-19 vaccinations for their wards. And so they're looking at, again, that question, what's the reasonable person standard, what a reasonable person in the ward's position would do. Guardians are also required to maximize what is best for the ward, including the least intrusive means, the most normalizing means, the most integration in their community, the least restrictive means, and the most appropriate to the person's needs. Next slide. So a lot of times when we talk about guardianship, we talk about the best interest balance. So on one side of the balancing scale, you want to keep your ward safe, healthy, and financially secure. On the other side, you want to make sure your ward is independent in the least restrictive setting, and that your guardianship is ward centered and they're making as many decisions as they can. Next slide. Unfortunately, go ahead and click the next two ones, India. Thank you. Unfortunately, a lot of times what we see is that this best interest analysis ends up being way overly restrictive. So we see guardians who don't let the ward communicate with their friends, don't let the ward communicate with their partner, don't tell the ward what's going on, don't see the ward often enough, don't include them in any decision making. That's going to be overly restrictive, and they're not, at that point, they don't have independence, they don't have any sort of input in what's going on in their lives, and they're being very restricted and their rights are being curtailed. And that's something that we get really concerned about and something we see a lot in the guardianship work that we do. Next slide. So guardians also have the responsibility of being professional. They have to show good character and integrity. They have to act above reproach. There can be no financial or sexual exploitation of the ward or anybody else, and no other acts that are not in the best interest of the ward. If you act in a way that is contrary to the best interest of the ward, that is a very quick way to get you removed as guardian. They have to exercise due diligence. They have to make sure that they're keeping up with things. They have to make sure that they're keeping up with services, making sure they're keeping up with payments, maintaining all that sort of stuff, and communicate with the ward and be fully informed about what's going on with the ward. It is not uncommon for us to hear about guardians who aren't paying the rent for their ward, and now the guardian or the ward has been kicked out. And so that's not something we want to see. If you're going to have the restriction of rights, the point of the restriction of rights is to make sure those things are being done. So it's really important that those things are being done if a guardianship is established. They have the responsibility to do the least restrictive alternative in all cases and to do person-focused planning. So even though the guardian has ultimate decision-making power, they should be including the ward in all the decisions that they possibly can. Give them the full potential, balance the maximum independence for the ward, and make sure that they are as self-reliant as possible with the best interest in mind. Next slide. They also have to foster positive relationships, both with the ward themselves and between the ward and other people. You're not supposed to be isolating the ward from everybody that they care about or everybody that they want to be involved in their lives. They have to communicate with the ward. They're supposed to know what the preferences and belief systems of the ward are so they can act in accordance with that. That's part of the best interest of the ward, is what the ward would want if the ward had capacity to make that decision. And their preferences and beliefs aren't related to their capacity. That's different. And so just because you don't have the same beliefs as the ward doesn't mean that your beliefs trump the decisions of the ward. You're required to have quarterly meetings with your ward to make sure that you are maintaining that relationship and they know what's going on in their life and you know what's going on in their life. Private communication with the ward, ongoing assessment of the conditions and needs of the ward. Notify the court if anything's going wrong, if there's a level of care that's not being met, if you're having issues getting providers, or if there's any other questions that you have about what's going on in the guardianship. And keep documentation of any complaints by the ward so that when the court finds out about complaints that are being made, they're not caught off guard thinking that you've been hiding something that the court has, or that the ward has been trying to tell the court. Next slide. So again, if you are the guardian, you cannot provide direct services to the client unless you are authorized by the court if you are their family member. If you're a third party, that's different, but family members cannot be a direct service provider unless they have specific designation from the court. And that can be pretty hard to get. They have to monitor and coordinate services and benefits, and make sure that they have an understanding of extraordinary medical issues. So seeking ethical, legal, and medical advice, and again, honoring the ward's preferences and belief system. This also applies to end-of-life decisions, but it applies to end-of-life decisions, but also reproductive decisions. And those are the cases we see most often when we're talking about disagreements based on beliefs. And they have a duty of confidentiality to their ward and not letting people who don't need to know what's going on with the ward know what's going on with the ward, essentially. Next slide. Another common question we get asked is, if something bad happens because of the ward, can the guardian be held responsible? So as long as the guardian is acting in good faith, sincere motives without any intent to defraud or harm anybody else, and with ordinary prudence, care, and diligence, essentially just acting as a reasonable person, they should not be held accountable for any losses are happening to or from their ward. So if a ward has a behavioral issue and does damage or commits a crime or something like that, as long as the guardian was behaving as a reasonably prudent person and had acting in good faith, they shouldn't be held liable for any of that. Next slide. So another common question we get is, can I still participate in medical care if I don't have a medical POA or guardianship? So a lot of people are concerned that once their child turns 18, they won't be allowed to be in the room or help make appointments or anything like that. So generally, when it comes to medical care, if you just want to be kept informed and be able to make appointments and that sort of thing, if the ward can sign a HIPAA release, that's all you should need to know. As long as the patient is able to give consent, they can just say, yes, I want my parent in the room, or yes, I want my parent involved, or whoever involved, and they can sign that release, and that should be significant enough. If a patient is not able to consent, they come in unconscious or something like that, then it's in the doctor's judgment to decide whether or not you can be involved. A lot of times they will let you be involved if there's nobody else to make a decision, because they need a decision to be made. And a lot of questions we get is whether or not a parent can give consent or make treatment decisions. Again, if the patient or the ward consents to this, the potential ward consents to this and says they want assistance making decisions, then you are allowed to do that. If it's urgent, the doctors may treat it as implied consent or an emergency exception. And then if the patient's unable to give consent and it's not urgent or an emergency, then the parent would either need a POA, a power of attorney, or guardianship in order to provide consent. Next slide. So now I'm going to talk about the continuum of supports. Next slide. So there are many different options to support decision-making. Like, we talk about supported decision-making as a general alternative to guardianship, but that actually looks a lot of different ways for different people. And that's kind of the idea of it, is allows you to mix and match and create a system that works best for your family, your client, whoever we're talking about. It considers from least restrictive to most restrictive, and also considers different ways of providing support other than just making the decision on behalf of the person. Next slide. So we're first going to talk about the continuum of supports in terms of daily decisions. So you'll see the bar on the side of the screen. Least restrictive is on top, most restrictive is on bottom. So we're always going to want to start from the top of the screen to move down and see where that sweet spot is between balancing the safety and security of the ward versus making sure they maintain their independence. So many people with disabilities only need informal support or assistance, and that can be things like direct deposit or something like that. Then we have different forms of supported decision-making, which can include releases of information to allow you to be informed about what's going on, authorized representative designation, so you can be involved in processes where there may be a confidentiality requirement, protection orders, powers of attorney, conservatorship, limited guardianship, and then full guardianship of the person is the most restrictive alternative. Next slide. We have a similar continuum of supports when it comes to financial decisions. Again, least restrictive on top, most restrictive on the bottom. We want to start at the top. So again, informal support can look like direct deposits, payments, automatic payments from your bank account, supported decision-making, including releases of information, trusts established to protect the finances of a person, powers of attorney, conservatorship, representative payee designation, limited guardianship, and full guardianship of the estate. Next slide. And don't worry, I'm going to talk about each of these more in depth in here in a minute. So how to informal support. Everybody needs some form of support. That's what we started this talking about. Everybody needs some support in making decisions. And so that's what informal support looks like. So for instance, it allows you to provide understandable information. You may just need to have easier to read information for the person to be able to make decisions with informal support, or the use of assistive technology. They may be completely capable of determining what their needs are and making their own choices if they have the ability to communicate or understand something in a way that assistive technology can assist with. You can automate things when possible, including direct deposits, scheduled payments, or reminders to do specific things. So for example, I have ADHD. I need a lot of informal support, and a lot of that I've set up myself in the terms of direct deposits, scheduled payments, and a lot of alarms on my phone to make sure that I'm doing the things that I need to do because I have that need, that extra support need that I have. Next slide. There's also the option of a larger conversation about supported decision-making. So in Texas and Massachusetts, there are formalized processes to establish a supported decision-making plan and have it enshrined. That's not the case in Ohio. There's no formal process in the state of Ohio, but a committed team of people can and do figure it out on a daily basis. And we have lots of options and examples on what a supported decision-making plan might look like, and you can mix and match and create it the way you want to. You also can use informal supported decision-making where you just have agreements in place. So for some clients, for instance, the potential ward will have an agreement that before they make any spending decision over $200, they will call one of their support systems to discuss that decision and make sure it's a good choice. But you can have a formalized plan for support where you designate specific supporters, identify supporters and areas of needs, identify what kinds of things you're going to go to each supporter about, and what areas you want to maintain your own decision-making ability for. You can give that plan to supporters and others who will be interacting with the supporters so they understand what their responsibilities are, what they're agreeing to, and how best to support you. And it can evolve over time. Next slide. So these are some examples of supported decision-making plans. You can click on that link when I send out, when you get the the PowerPoint presentation, and that'll give you several different examples. Next slide. We're going to skip this video, but it goes through, I think it's a wonderful video to watch if you have time. And there's another one later on that I also think is really helpful to watch that kind of goes more in depth and gives you some examples of what supported decision-making can look like. So the next thing I want to talk about are releases and authorized representatives. And these are forms that the person with the disability can sign to authorize another person's involvement in a procedure. They can be revoked by the other, or another person can be appointed at any time. So if you have a release signed, you can revoke that at any time. A lot of times they also expire after a year. One thing to note, a durable healthcare power of attorney can be used as a release prior to transferring decision-making power. So if you were in that area where you are considering guardianship or you don't know if guardianship is appropriate or something like that, a durable healthcare power of attorney can be assistance to determine whether or not that's needed or while you go through that process. The other thing to take note of is a financial power of attorney is required by the Ohio Department of Medicaid to participate in any benefits proceedings if there's no guardianship or authorized representation designation on file. So if you simply have a medical power of attorney over your child, for instance, and you want to negotiate with Medicaid or with the county board of DD about the benefits or the services they're getting, they will not allow you to be a part of that conversation unless you have a guardianship, an authorized representation designation, or financial power of attorney. Because for their consideration, benefits are finances, not healthcare decisions. So that's something I always like to note for people because it doesn't always, people don't always understand that that's the rule under ODM. Next slide. Protection orders are an option if there is some reason why the potential ward is being abused or exploited in some way. These are, however, just civil protection orders, so they are going to be held to the same standard as a regular civil protection order. You have to show to the court why there's an ongoing and immediate danger to the ward, potential ward. And if you are interested in doing that, you would need to contact the local prosecutor, victim advocate, or court-appointed DD advocate to assist in getting a protection order. Next slide. Again, trust can be a wonderful option. Trust can be used to protect assets or direct spending for a ward, protect them from being collected by creditors if a ward has a tendency to overspend or not control their money very well. And if you are interested in learning more about trust, I would encourage you to consult with an attorney who specializes in trust and can help you determine what trust is appropriate for your particular situation. Next slide. This is one of the most common questions we get is about powers of attorney. There are two main types of powers of attorney. One is the financial power of attorney, which gives you power over all financial assets and decision making. And the other is the healthcare power of attorney, which is about healthcare and medical decisions. There's also two different kinds, designations of those powers of attorney. So durable means it is effective now and continues even if the person loses capacity. And springing means it is not effective until the person loses capacity. So for instance, I mentioned people who have cyclical mental health conditions. I often encourage them to have springing powers of attorney set up so that while they are competent to make their own decisions, they can go ahead and make their own decisions. But once their capacity is no longer available, they can have somebody step in on their behalf and make decisions to make sure they get the care and treatment that they need. An individual must have the ability to understand what they're signing with support, which varies depending on how complicated the agreement is. If you have specific questions about whether or not you think the ward or the person with the disability has the capacity to understand the power of attorney, we can talk about that. But most of the time, as long as you can explain it in general terms and they understand the rights and the responsibilities that they're giving up, they can sign the form. There's also an example of one of the advanced directives. That's a medical POA. From Pro Seniors. Next slide, please. Another option is a representative payee. So you cannot personally appoint yourself or personally for your child appoint a representative payee. That is something that's determined by Social Security or the veterans benefits, and they will actually appoint a representative payee on the person's behalf. There are requirements for management, documentation, and reporting for a representative payee, and it does not allow control over anything other than the federal benefits that they're receiving. So whether that's Social Security benefits or VA benefits, it wouldn't give you full access to all of their finances, just the benefits that you were appointed to control. And if you have concerns about representative payees or the way a representative payee is behaving, feel free to contact DRO. We have a rep payee review program, and we can ask to open an investigation to determine whether or not abuse or misuse is occurring. Next slide. Another option that I'm going to just briefly talk about is conservatorship, which is essentially a consented to guardianship. It's very similar to a guardianship, except it is the person with the disability themselves who's going to the court and requesting that the conservatorship be established. Now, this is different because conservatorship and guardianship are used across the nation to mean different things. So if you hear about, for example, a conservatorship in the state of California, that's not the same thing as a conservatorship in the state of Ohio. So in Ohio, conservatorships mean something that is consented to and asked by the person with the disability for the court to establish. They actually will file a petition themselves. The court will hold a hearing and make sure that they actually are consenting to it and the conservator is appropriate, and then they will appoint them. One thing to note, conservatorships in the state of Ohio are generally only for people with physical disabilities, not for people with developmental or mental disabilities in any way. And again, because it is consensual, it can be terminated by the person who asked for the conservatorship in writing or filed by the court and then served on the conservator themselves. However, and the court can also themselves determine that the conservatorship is no longer appropriate if they determine the ward no longer can consent to it. So they can actually convert the conservatorship into a guardianship if they believe capacity has left the individual. Next slide. I also want to talk briefly about able stable accounts. So as some of you or many of you may know, there are restrictions on the amount of assets that people who are receiving federal benefits can receive and maintain. And so an able stable account allows individuals with disabilities to save or invest up to $14,000 a year without impacting their benefits or their eligibility for benefits. So there's no taxes on the money that's while it's in the account or upon the withdrawal. But there are restrictions on what the money can be spent on. So you'll see at the bottom, there are some designations as to what kind of categories you can spend the money on. And there are wonderful information on able stable accounts and a website I'm going to provide later in the presentation. Next slide. So that is essentially the end of the presentation. But there are some resources that I have here, including our website, general legal resources, Pro Seniors, which is a wonderful resource for a lot of advanced directives. The Ohio State Bar Association also has a lot of resources. And then, like I said, the stable account website is very helpful as well. I think there's some more.
Thank you so much, Maggie. That was so explanatory. I want to thank you so much. And you just smoothly went through that. So thank you. I'm going to check to see what questions we have. We do have some questions. Okay. This one says, is there a difference between guardianship and conservatorship, as in the very public case of Britney Spears? I knew someone was going to at least bring up our girl Britney, right?
Yeah. As I mentioned, so conservatorship in the state of Ohio is very different than it is in California. So all the states use similar terms. They all use guardianship and conservatorship, but they all mean different things. So for example, in California, conservatorship is more like a full guardianship of the person in Ohio, but also the restrictions are different. So you actually have more rights as a ward in the state of Ohio than you do in the state of California. And this difference, like I said, it varies from state to state. For instance, in Alaska, what they call a conservatorship is a guardianship of the estate here in Ohio. So you're always going to want to make sure you're looking at very state local resources because it's different. And this stuff is pretty niche. So if you're looking for legal advice, I would really encourage you to look for attorneys who have experience in disability rights and specifically experience in probate matters, because it's not super common for attorneys to have that experience.
All right, thank you. The next question, do you have adaptive explanation of rights for someone who can't read well with visual supports, short concrete sentences?
I believe we do for some of our resources. We do have some easy read resources available on our website. Specifically, I know all of our voting rights resources, we also have an easy read formats. In terms of our guardianship resources, I would have to double check and make sure that they're not overly complicated. And if you need specific explanations that are simpler and easy read, I am happy to provide specific consultation and answer any questions as to what that might look like. But our resources are pretty straightforward. They pretty easily lay out exactly what's going on. And we also have, the other thing I forgot to mention is for wards who want to request any of their rights for a hearing or appointment of an attorney or an independent evaluator or any of their other legal rights for their hearings, we actually have a form that they can fill out where they just enter like their specific case information and check any of the rights they would like to request, and they can submit that directly to the court, which is a lot easier for wards to use sometimes.
All right. Well, that is the only 2 questions I see, which means that you did a really good job. I want to thank you again. I'm going to put your email address in the chat box for everyone really quick.
That's my email.
Yeah, and then I will also include it in a follow-up email that I'm going to send out to everyone. But again, I just want to thank you. You pretty much made this really easy for us to kind of understand and to kind of grasp, especially the importance of making sure that the ward has rights. That was the main, focus that I really wanted people to pick up, So thank you so much. There's no more questions, so I will talk with you soon. Of course, we'll stay in touch. And everybody else, please have a great, safe day. Her email address is in the chat box, and I also will include that in our follow-up email. Okay. All right. Thank you. Have a good one. Bye, everyone.